some tweets from members of Congress as they're in a quorum call here on the Senate floor. Again, earlier they passed the Oversight of Drug Compounding Centers bill. It's on its way to the President for his signature. And they debated some of the nomination of Robert Wilkins to the D.C. Court of Appeals. And a vote on that nomination expected to be held after 5:30 Eastern Time. Also a possible vote on taking up defense programs. 60 votes needed on both of those to pass. And the Hill reports on the Wilkins nomination. He says Republicans are expected to block the nominee.
The time until 5:30 p.m. will be equally divided and controlled in the usual form. Senator from Maryland.
Mr. President. Mr. President, I rise today in strong support of the nomination of Judge Robert L. Wilkins to be a circuit judge for the United States Court of Appeals for the District of Columbia. I was pleased to introduce Judge Wilkins to the Judiciary Committee in September, and the committee favorably reported his nomination in October. Judge Wilkins currently serves as a federal district judge for the U.S. District Court for the District of Columbia and was unanimously confirmed by the Senate for this position in 2010. I urge the Senate to invoke cloture to allow an up or down vote on this extremely qualified nominee. Judge Wilkins is a native of Muncie, Indiana. He obtained his B.S. cum laude in chemical engineering from Rose-Hulman Institute of Technology and his J.D. from Harvard Law School. Following graduation, Judge Wilkins clerked for the Honorable Earl B. Killiam of the U.S. District Court for the Southern District of California. He later served as a staff attorney and as head special litigation for the Public Defender Service for the District of Columbia. He then practiced as a partner with the venerable law firm specializing in white-collar crime, intellectual property, and complex civil litigation before taking the bench as a judge. Besides Judge Wilkins' professional accomplishments as an attorney, he has played a leading role as a plaintiff in the landmark civil rights case in Maryland involving racial profiling. During his tenure with the Public Defender Service and in private practice, Judge Wilkins served as the lead plaintiff in Wilkins v. State of Maryland, a civil rights lawsuit against the Maryland State Police for a traffic stop they conducted on Judge Wilkins and his family. In 1992, Judge Wilkins attended his grandfather's funeral in Chicago and then began an all-night road trip home with 3 family members. Judge Wilkins was due back in Washington, D.C. that coming morning for a court appearance as a public defender. A Maryland State Police trooper pulled him over. The police detained the family and deployed a drug-sniffing dog to check the car after Judge Wilkins declined to consent to a search of the car, stating there was no reasonable suspicion. The family stood in the rain during the search, which did not uncover any contraband. Judge Wilkins later said that it's hard to describe the frustration and pain you feel when people pressure you to be guilty for no good reason, and you know that you are innocent. We fit the profile to a T. We were traveling on I-68 early in the morning in a Virginia rental car, and my cousin and I, the front seat passengers, were young black males. The only problem was that we were not dangerous, that they were not guilty of anything. It should not be suspicious to travel on a highway early in the morning in a Virginia rental car, and it should not be suspicious to be black. After the traffic stop, Judge Wilkins began reviewing the Maryland State Police data and noticed that while a majority of those drivers searched on I-95 were black, blacks made up only a small minority of the drivers traveling on the road. Judge Wilkins filed a civil rights lawsuit which resulted in 2 landmark settlements that were first to require systematic compilation and publication by police agencies of data for all highway drug and weapon searches, including data regarding the race of the motorist involved, the justification for the search, and the outcome of the search. The settlement also required the state police to hire an independent consultant, install video cameras in their vehicles, conduct internal investigation of all citizen complaints of racial profiling, and provide the Maryland NAACP with quarterly reports containing detailed information on the number, nature, location, and disposition of racial profiling complaints. These settlements inspired a June 1999 executive order by President Clinton, congressional hearings, and legislation that has been enacted in half of the 50 states. It was a landmark case. It pointed out the right way in which we should have oversight and the right way to end racial profiling. And Judge Wilkins took the leadership and did something that many of us, I think, would have had a hard time doing, putting himself forward in order to do what was right. As my colleagues know, I have introduced S-1038, the End Racial Profiling Act, which would codify many of the practices now used by the Maryland State Police to root out use of racial profiling by law enforcement. The Judiciary Committee held a hearing on ending the use of racial profiling last year, and I am hopeful that with broader discussions on racial profiling generated by the tragic death of Trayvon Martin, that we can come together and move forward on this legislation. Judge Wilkins played a key role in the passage of the federal statute establishing the National Museum of African American History and Culture Plan for Presidential Commission, and he served as the chairman and the Site and Building Committee of that Presidential Commission. The work of the Presidential Commission led to the passage of Public Law number 108-184, which authorized the creation of the National Museum of African American History and Culture. This museum will be the newest addition to the Smithsonian and is scheduled to open in 2015 between the National Museum of American History and the Washington Monument on the National Mall. Judge Wilkins continues his pro bono work to this day. He currently serves as the court liaison to the Standing Committee on Pro Bono Legal Services of the Judicial Conference of the D.C. Circuit. He is committed to public service. He is committed to equal justice under the law. As a U.S. District Judge for the District of Columbia since 2011, Judge Wilkins has presided over hundreds of civil and criminal cases, including both jury and bench trials. Judge Wilkins already sits on a federal bench which hears an unusual number of cases of national importance to the federal government, including complex election law, voting rights, environmental, security, and administrative law cases. Indeed, Judge Wilkins has been nominated for the appellate court that would directly hear appeals from the court on which he currently sits. He understands the responsibilities of the court that he's been nominated to by President Obama. The American Bar Association gave Judge Wilkins a rating of unanimously well qualified to serve as a federal appellate judge, which is the highest possible rating from the nonpartisan peer review. The U.S. Court of Appeals for the District of Columbia Circuit is also referred to as the nation's second highest court. The Supreme Court only accepts a handful of cases each year, so the D.C. Circuit often has the last word and proclaims the final law of the land in a range of critical areas of the law. Only 8 of the 11 court seats authorized by the court are filled, resulting in a higher than 25% vacancy rate on this critical court. It is today with large vacancy numbers. The court handles an unusually complex cases in the area of administrative law, including reviewing decisions and rulemaking of many federal agencies and policy areas such as environmental, labor, and financial regulations. Nationally, only about 15% of the appeals nationwide are administrative in nature. In the D.C. Circuit, that figure is 43%. They have a much larger caseload of complex cases. The court also hears a variety of sensitive terrorism cases involving complicated issues such as enemy combatants and detention policies. Let me just quote from former Chief Judge Henry Edwards, who said, "Review of large, multi-party, difficult administrative appeals is the staple of the judicial work in the D.C. Circuit. This alone distinguishes the work of the D.C. Circuit from the work of other circuits. It also explains why it's impossible to compare the workload of the D.C. Circuit with other circuits by simply referring to raw data of case filings," end quote. And Chief Justice Roberts noted that about 2/3 of the cases before the D.C. Circuit involve the federal government in some civil capacity, while that figure is less than 25% nationwide. He also described the D.C. Circuit's unique character as the court with special responsibility to review legal challenges to conduct the national government. So, Mr. President, we have a person who is eminently qualified for this position in Judge Wilkins. We have a need to fill these vacancies. The Senate should carry out its responsibility and conduct an up or down vote on Judge Wilkins' nomination. We're going to have a chance to do that in a few moments. And let me remind my colleagues that the Senate unanimously confirmed Judge Wilkins in 2010 for his current position, and he has a distinguished lifelong record of public service. I ask the Senate, my colleagues, to vote so that we can move forward and get an up or down vote on this eminently qualified judge, and I hope my colleagues will support his confirmation. With that, Mr. President, I would suggest the absence of a quorum.
Clerk will call the roll.
Mr. Alexander.
Senator from Vermont.
Mr. President, I ask consent to call the quorum be dispensed with.
Without objection.
Mr. President, I listened to the words of my good friend from Maryland, and the senator from Maryland is absolutely right in what he said. It is a strange time. You know, I've been here almost 4 decades, and I've experienced some dramatic changes in Senate majorities and leadership styles going back and forth between both parties. But nothing at all has compared to the change that's occurred here in the last 5 years. Since President Obama was sworn in as President of the United States, something I've never seen with any other president. I've been here since the time of President Ford. Senate Republicans have made it their priority to obstruct at every turn the consideration of nominations that he has put forward. Republican leaders said his main goal was to have the president fail. Confirmation votes have regularly occurred by consent. Now you have to have cloture. Bipartisan home state support for a nominee no longer is what's needed for a timely confirmation. Make no mistake, Mr. President, what's happened in this obstruction, Senate Republicans across the line from the use of the Senate rules to the abuse of the Senate rules. It's the same kind of abuse that shut down our federal government recently, costing the taxpayers billions of dollars. But one of the things that concerns me as chairman of the Senate Judiciary Committee, what it is doing to undermine and eventually destroy both the integrity and the independence of our federal judiciary. One of the great glories of our three-part government in this country is that the federal judiciary has always been independent. We've kept it out of politics. This last 5 years, they've dragged it into politics. And more than that, the same kind of Republican obstruction has left the federal judiciary often with 90 or more vacancies throughout this country over the past 5 years. Now, if you're a litigant and you need the protection of our federal courts, you don't care whether they're Republicans or Democrats. You don't care whether they were supported by a Republican or a Democratic president. All you want, whether you're a plaintiff or defendant, state or respondent, you want to be able to go into that courthouse and be treated fairly. Now you can go to that courthouse and there's nobody there. 90 vacancies caused by the stonewalling on the other side of the aisle. You know, the same Republicans who were stonewalling once insisted that filibustering of judicial nominations was unconstitutional. They said very clearly when there was a Republican president, if you're going to filibuster judicial nominations, that's unconstitutional. Well, the Constitution didn't change when Barack Obama became president, but whoop-de-doo, suddenly their attitude changed on this. They reversed course, and I'll tell you how bad it was. If anybody talked about filibustering a judge when there's a Republican president, they all be on the floor saying, oh, this is unconstitutional. Now, I don't know what there is different about this president But the very first name he had out here, the very first one, they filibustered that judicial nominee. Can you imagine? This is the precedent they started. The very first, within a very short time after the president was sworn in, very first person. Oh, incidentally, that judicial nominee was strongly supported by the most senior Republican senator here. The most senior Republican senator supported, but the leadership said, oh, no, we've got to filibuster and block, because after all, it's President Obama who nominated him, not President Bush. And they filibustered 34 President Obama's judicial nominees. The president's only been there 5 years. That's twice as many nominees that require cloture during 8 years of President Bush's terms. Most of them were by any standard, non-controversial. Most of them were supported by well-known names in the law, both Republicans and Democrats. But we still had to fight and get cloture to get them through. Most recently, the Senate Republicans decided to filibuster a well-qualified nominee after well-qualified nominee for the United States Court of Appeals for the D.C. Circuit. Court has 3 vacant seats. Now, during the Bush administration, the Senate confirmed President Bush's nominees to the 9th, and the 10th, and the 11th seat, and then there was a vacancy in the 10th seat to the 10th seat again. But now, when a new president has been elected, I might say re-elected by a solid majority, the Senate Republicans say, oh, no, wait a minute. We needed those judges when it was a Republican. We don't need them now that it's a Democrat. It's an unprecedented level of obstruction. In my 4 decades here, I've never seen anything like this by either party, what the Senate Republicans are doing. In fact, let's say the distinguished presiding officer who was from Maine, the former senior senator from Maine, well-respected Republican in this body, Olympia Snowe, recently said when you have these back-to-back rejections of nominees, at some point it may be trying to reverse the results of the election. Now, tonight we're going to try to end the filibuster against Judge Robert Wilkins. He's got the highest rating possible by the American Bar Association. When he was up for the U.S. District Court, he was confirmed unanimously. He's presided over hundreds of cases. He's issued significant decisions in various areas of the law. Prior to serving the bench as a partner for 10 years in private practice and 10 years as public defender in the District of Columbia. This is a man who, in past presidents and past senates, would probably go through by a voice vote after dozens of senators in both parties had stood on the floor to praise him. But the difference is he was nominated by President Obama, and suddenly they're trying to block him. This is a man who served as the lead plaintiff in a racial profiling case, which rose out of an incident in which he and 3 family members were stopped and detained while returning from a funeral in Chicago. The lawsuit led to landmark settlements that required systematic statewide compilation publication, highway traffic stop and search data by race. Inspired an executive order by President Clinton, legislation in the House and the Senate, and legislation in at least 28 states prohibiting racial profiling or requiring data collection. A landmark case the distinguished presiding officer and I come from states where we hope we don't have racial profiling. But most of us look alike in the states of Maine and Vermont. But many of us, many senators here know there are cases of racial profiling, and they should be stopped. Mr. President, I'm aware of that happening even to members of my own family. Maybe with some of these change, if we have more diversification in our federal bench, you know, if Judge Wilkins is confirmed, he's only going to be the 6th African American to ever have served in what's often considered the second most powerful court in our country, the D.C. Circuit. Again, with the highest qualifications. I mean, most people who are nominated by either Republicans or Democrats, no matter who they are at the courts, wish they had his experience, wish they had his qualifications. In fact, I'd ask unanimous consent to include a list of support from many in the record.
Without objection.
So all I'm saying, Mr. President, Republicans said the D.C. Circuit should be operating at full strength when President Bush held office. What is the difference between President Obama and his nominees? If it made sense to be operating at full strength under a Republican president, should it be operating at full strength under a Democratic president? Yesterday's Washington Post editorial said, quote, "It's transparently self-serving of GOP lawmakers to oppose D.C. Circuit nominees only when it's a Democrat's turn to pick them." They're right. I'd ask to put that in the record.
Without objection.
And I'd ask to put my full statement in the record.
Without objection.
And, Mr. President, the halls are full of people talking about whether we're going to have a change in the cloture rule. This kind of pedophilery, this kind of delay for the sake of delay, this kind of treating this president different than other presidents. That's why there's momentum toward a change in our rules. I yield the floor.
All time has expired. Under the previous order, the clerk will report the motion to invoke cloture.
Cloture motion. We, the undersigned senators, in accordance with the provisions of Rule 22 of the Standing Rules of the Senate, hereby move to bring to a close the debate on the nomination of Robert Leon Wilkins of the District of Columbia to be United States Circuit Judge for the District of Columbia Circuit, signed by 17 senators.
By unanimous consent, the mandatory quorum call has been waived. The question is it the sense of the Senate that debate on the nomination of Robert Leon Wilkins of the District of Columbia to be United States Circuit Judge for the District of Columbia Circuit shall be brought to a close? The yeas and nays are mandatory under the rule. The clerk will call the roll.
Mr. Alexander, Ms. Ayotte, Ms. Baldwin, Mr. Barrasso, Mr. Baucus, Mr. Begich, Mr. Bennett, Mr. Blumenthal, Mr. Blunt, Mr. Booker. Mr. Bozeman. Mrs. Boxer. Mr. Brown. Mr. Burr. Ms. Cantwell. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Chambliss. Mr. Coates. Mr. Coburn. Mr. Cochran. Ms. Collins. Mr. Coons. Mr. Corker. Mr. Cornyn. Mr. Crapo. Mr. Cruz. Mr. Donnelly. Mr. Durbin. Mr. Enzi. Mrs. Feinstein. Mrs. Fisher. Mr. Flake. Mr. Franken. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mrs. Hagan. Mr. Harkin. Mr. Hatch. Mr. Heinrich. Ms. Heitkamp. Mr. Heller. Ms. Hirono. Mr. Hoven. Mr. Inhofe. Mr. Isaacson. Mr. Johans. Mr. Johnson of Wisconsin. Mr. Johnson of South Dakota. Mr. Kane. Mr. King. Mr. Kirk. Ms. Klobuchar. Ms. Landrieu. Mr. Leahy. Mr. Lee. Mr. Levin. Mr. Manchin. Mr. Markey. Mr. McCain. Mrs. McCaskill. Mr. McConnell. Mr. Menendez. Mr. Merkley. Ms. Mikulski. Mr. Moran. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Nelson. Mr. Paul.
Look at my playlist speech.
Mr. Portman. Mr. Pryor. Mr. Reed of Rhode Island. Mr. Reed of Nevada.
Mr. President.
Mr. Risch. Mr. Roberts. Mr. Rockefeller. Mr. Rubio. Mr. Sanders. Mr. Schatz. Mr. Schumer. Mr. Scott.
No.
Mr. Sessions. Mrs. Shaheen. Mr. Shelby. Ms. Stabenow. Mr. Tester. Mr. Thune. Mr. Toomey. Mr. Udall of Colorado. Mr. Udall of New Mexico. Mr. Vitter. Mr. Warner. Ms. Warren. Mr. Whitehouse. Mr. Wicker. Mr. Wyden. Senators voting in the affirmative: Baucus, Booker, Cardin, Carper, Collins, Coons, Donnelly, Franken, Hagan, Heinrich, Heitkamp, Johnson of South Dakota, Kane, King, Leahy, Levin, Manchin, Markey, Menendez, Nelson, Pryor, Reed of Rhode Island, Sanders, Schatz, Shaheen, Warren, Wyden. Ms. Cantwell, aye. Mr. Udall of New Mexico, aye. Ms. Baldwin, aye. Ms. Klobuchar, aye. Mr. Tester, aye. Senators voting in the negative: Alexander, Barrasso, Burr, Chambliss, Coates, Coburn, Cochran, Cornyn, Crapo, Cruz, Fisher, Flake, Grassley, Heller, Hoeven, Inhofe, Johans, Johnson of Wisconsin, Kirk, Lee, McCain, McConnell, Moran, Risch, Roberts, Sessions, Shelby, Toomey, Wicker. Mr. Scott, no. Ms. Mikulski. Ms. Mikulski, aye. Mrs. Boxer. Mrs. Boxer, aye. Mr. Casey, aye. Mr. Enzi, no. Ms. Ayotte, no. Mr. Paul, no. Mr. Corker, no. Mrs. Gillibrand, aye. Ms. Hirono, aye. Mr. Udall of Colorado, aye. Mr. Thune, no. Mr. Whitehouse, aye. Mr. Bozeman, no. Mr. Portman, no. Mr. Blumenthal, aye. Mr. Brown, aye. Mr. Murphy, aye. Mrs. McCaskill, aye. Mr. Harkin, aye. Ms. Murkowski. Ms. Murkowski, aye. Mr. Merkley. Mr. Merkley, aye. Mr. Rockefeller. Mr. Rockefeller, aye. Mrs. Feinstein. Mrs. Feinstein, aye. Mr. Bennett. Mr. Bennett. Aye. Mrs. Murray. Mrs. Murray. Aye. Mr. Durbin. Mr. Durbin. Aye. Ms. Stabenow. Ms. Stabenow. Aye. Mr. Reed of Nevada. Mr. Reed of Nevada. Aye. Mr. Schumer. Mr. Schumer. Aye. Mr. Reed of Nevada. Mr. Reed of Nevada, no.
Senate will come to order. On this vote, the yeas are 53, the nays 38, one senator responded present. 3/5 of the senators duly chosen and sworn not having voted in the affirmative. The motion is not agreed to.
Mr. President,
The Majority Leader.
I enter a motion to reconsider the vote by which cloture was not invoked on the Wilkins nomination.
The motion is entered. Under the